Tonight's first guest, Harvard Law Professor Emeritus and Newsmax contributor Alan Dershowitz. He is the author of a new book called Guilt by Accusation, The Challenge of Proving Innocence in the Me Too Age. And we'll get to your countersuit, Professor Dershowitz, against Virginia Giuffre a bit later. But let's start with these public impeachment hearings. What we learned today is House Intelligence Chairman Adam Schiff is going to put it in writing this week that Republicans may justify the relevance of any witness they want to call in for testimony, really giving Democrats the final say on who is going to be able to come before the dais. You know, given everything we've seen so far with the way Democrats have handled this situation, do you think that's the best strategy for them?
Oh, absolutely not. It would be as if in a trial, the one side had to give the other side permission to call a witness. Both sides should have equal access to witnesses, to documents, to evidence. There's no such thing in law as one side's witness. Every witness is supposed to be the witness for the truth, and the Republicans should have equal right to call witnesses and Democrats. Indeed, probably more, because the defendant, in this case, the person who is being subject to the possibility of impeachment, you generally err on the side of allowing them to have witnesses. For example, the Sixth Amendment provides that the defense can call witnesses. There's nothing in the Constitution that talks about the prosecution being able to call witnesses. That's up to the discretion of the court. So the Democrats in this case have it backwards.
And we've heard a lot about the Sixth Amendment this week, your right to face your accuser. We also wanted to point to something that Jerry Nadler had to say, the chairman of the House Judiciary Committee. He was on CNN talking about how his committee is handling things.
We're going to have full due process for the president, and that means that if there's any exculpatory evidence, any evidence tending to show that he's innocent, whether it's witnesses or anything else, they'll be able to bring it forward. Maybe that will change people's minds.
Now, so much of what we've seen so far has been happening in closed-door secret hearings dealing with the House Intelligence Committee, but the Judiciary Committee is really where the rubber meets the road in the impeachment process. Do you believe that Jerry Nadler can actually provide full due process?
Well, I hope so. And certainly the presumption should be in favor that any committee of Congress should provide due process. But we live in such a partisan world that it's very, very difficult to imagine either side, when they control one of the chambers of Congress, providing a full and complete and equal due process to the other side. That's why we really look to courts and judges and juries rather than Congress to get to the truth and to do justice. And that's why it's wrong to say that a president or appointees of the president obstruct Congress when they refuse to simply comply with congressional wishes. We have a system of checks and balances in which the branches of government are co-equal. And so if the executive branch believes it has a plausible argument for not turning material or witnesses over to the legislative branch, the issue has to be resolved by the judicial branch. That's called checks and balances. It's not called obstruction of Congress.
Three co-equal branches of government. All right, let's talk about one of the officials here that's going to testify next week, and that's former Ukrainian Ambassador Marie Yovanovitch. But there's now a report that she communicated with a Democratic staffer through a personal email days after the whistleblower complaint was filed, and she possibly lied about it in her closed-door hearing. Is this perjury, and if so, should she be accepted as a witness moving forward?
Well, even perjurers sometimes tell the truth about certain things. I'm not going to call her a perjurer. I have no idea whether she did or didn't lie. I think you always have to err on the side of presuming a person innocent. And perjury is a very hard crime to prove. You have to prove not only that the person deliberately and willfully misstated the truth, but that that misstatement was material to the investigation. So I think we ought to stay away from throwing around terms like perjury, or when Vindman was on television, words like espionage or treason. Crimes are defined by the statute. For example, the other day, a whole bunch of people on other networks were talking about it being a crime to reveal the name of a whistleblower. I spent the afternoon looking through the statutes. I couldn't find any statute that made it a crime to reveal a whistleblower. It is illegal to retaliate against a whistleblower, but Congress never decided to make it a crime for a newspaper to print the name if they could find it, or for a public official to release the name. So, we have to stay away from inventing crimes and just thinking that everybody who does something we don't agree with is guilty of the crime of collusion. There's no such crime.
Right, doesn't exist.
Congress. There's no such crime as obstruction of Congress or revealing the name of whistleblowers. It's very dangerous to invent new crimes without Congress and the president authorizing through statutes the definition of a new crime.
Yeah, and I mean, when you talk to somebody who really believes the president should be impeached and removed from office, you ask them what crime, what high crime or misdemeanor is the president guilty of, and oftentimes they have a hard time answering that in a one-sentence answer. Now, the attorney for the Ukraine whistleblower, you talked about this, has sent a cease and desist letter to the White House telling the president to stop attacking his client. We know the president hasn't named the whistleblower publicly, but do you think this is necessary, this cease and desist letter?
Well, lawyers do that. It's part of their responsibility to advocate for their client. They have no impact. The cease and desist letters are just, like letters to the editor. You can ignore them, and they have no relevance at all. In certain jurisdictions, you have to first write a cease and desist letter before you can sue for certain kinds of civil actions. But in this case, it's just a letter by a lawyer. And the lawyer is right about this. You cannot retaliate. And if you do retaliate, or if you do reveal the name and that results in injury to the person or family, there could be civil lawsuits. So, civil lawsuits are possible even without a statute.
And I think that's the overabundance and caution that a lot of these news organizations are using. Why they're choosing not to is because you don't want to do anything that could lead to a civil lawsuit or somebody getting hurt, this case being the whistleblower.
Or even the decent thing. Just do the decent thing, because you don't name the person if there's any possibility that people could go after him or he could lose his job or something like that. So,
you can't independently verify that identification, which is holding up a lot of us right now. All right, we got about a minute and a half left, Professor, and I wanted to get to your lawsuit right now. You're suing Virginia Giuffre, one of the accusers in the Jeffrey Epstein case. You're suing her for defamation and for intentionally inflicting emotional distress against you. And also, I read today, David Boies, Giuffre's attorney, is now countersuing you as well, but you claim Boies is more concerned about destroying you than actually getting justice for his clients.
Well, I'm actually very happy that he sued me for defamation for calling him an extortionist, because that invites me now to litigate his entire career. We're going to put his entire career in front of the court. How he endangered the lives of innocent people in his role in Theranos, how he participated in pressuring and threatening journalists in the New York Times and a Black Cube case, how he threatened a young writer named Emma Klein, activities of this kind. And he's opened up a Pandora's box that probably threatens the future of his law firm. It certainly threatens his own future because he's had many, many ethics charges brought against him in front of bars. And this time he will have to respond in public for the first time to my cross-examination of him on his career. So be careful what you ask for. I think Boies will rue the day that he sued me in an open-ended way that allows me to put his whole career on trial.
Well, we'll stay on top of it. Keep us posted what comes of it. And once again, we remind everybody about the new book, Guilt by Accusation, The Challenge of Proving Innocence in the Me Too Age. Great to see you, Professor Dershowitz. Thank you for your time.